Imagine trying to build a completely new democratic nation from scratch while inheriting decades of deep systemic inequalities. It's like a giant puzzle, right? How on earth do you balance absolute fairness for a single individual with the urgent need to achieve historical justice for a newly enfranchised majority? Well, that is the exact conflict at the heart of an absolutely fascinating legal drama from South Africa. Today, we're exploring the landmark constitutional court case Minister of Finance versus Van Heerden. This is a case that forces us to really ask ourselves, what does true equality actually look like in the real world? Okay, let's dive into this. We're going to cover a tale of two parliaments, the differentiated pension scheme, the discrimination lawsuit, defining equality in South Africa, and finally, the final verdict. Section 1. A tale of two parliaments. To really grasp what went down here, we have to journey back to the pivotal democratic transition of 1994. During those intense negotiations, a massive logistical headache emerged. The politicians of the old apartheid-era parliament understandably wanted to secure their own financial futures before handing over power. So what did they do? They established a closed pension fund using public money, which basically guaranteed highly generous benefits for those old members. It was a golden parachute, but here's the darkly comedic catch. When the newly elected, fully democratic parliament arrived in April of 1994, they found they had literally zero pension arrangements in place. Nothing. In fact, it took until 1998 for a new fund to finally be created and backdated. And it's incredibly crucial to understand exactly who made up this new parliament. According to the data from the case, an overwhelming 79% of the beneficiaries of the new pension scheme were black. So this vividly illustrates the stark racial dynamics of that transition. The vast majority of these new parliamentarians had been legally, systematically excluded from participating in the old government, and because of that, they were completely shut out of that lucrative closed pension fund purely on the basis of their race and political affiliation. Section 2. The differentiated pension scheme.
So, confronted with this massive financial gap between old and new members sitting right next to each other, the government had to figure out a way to level the playing field. They came up with a tiered system for the new pension fund, split into three categories for employer contributions. Category A was for new, younger members, and they got a 17% contribution. Category B, these were the new members 49 and older. They had the absolute greatest need, so they got the highest rate at 20%. And then you have Category C. These were the old members who were already receiving those massive benefits from the old closed pension fund. For them, the government set the contribution at just 10%. The whole goal was to prioritize public resources exactly where they were needed most to bridge that historical wealth gap.
Section 3. The discrimination lawsuit. Now, as you might expect, not everybody was thrilled with this tiered approach. Enter Mr. Frederick Jacobus van Heerden. He was a veteran parliamentarian, a former member of the National Party, who was actually re-elected in the Democratic 1994 elections. And because he was part of that old parliament, he fell into Category C, meaning he was getting that lower 10% contribution to the new fund. While he sued the Minister of Finance, he argued that paying Category C members less was a direct violation of the Constitution. He claimed it amounted to unfair discrimination based on race and political affiliation, basically saying, hey, you're punishing me for my past.
And here is the twist no one saw coming. The High Court actually agreed with Mr. Van Heerden. Yeah, the High Court judge ruled that the scheme was presumptively unfair. They basically said the state totally failed to prove that it was strictly necessary to pay the old members less in order to pay the new members more. The court argued there was no causal nexus, no direct link, proving that Category C absolutely had to lose out for Categories A and B to gain. So the High Court literally struck down the pension scheme, calling it unconstitutional, haphazard, and arbitrary.
Section 4. Defining equality in South Africa.
Obviously, the government appealed this, which brings us to the intellectual heart of the Constitutional Court's review. This is where high-level constitutional theory meets harsh historical reality. The court looked directly at Section 9, subsection 2 of the South African Constitution. This specific section authorizes what they call restitutionary measures. These are legislative or other measures specifically designed to protect or advance persons disadvantaged by unfair discrimination, all to promote the achievement of equality. And it's interesting, the court actually noted its preference for this term, restitutionary measures, over the American term affirmative action. They felt it much better aligned with South Africa's specific goal of repairing past harms, rather than just, checking demographic boxes.
And this brilliantly illustrates the Constitutional Court's core philosophy. They completely rejected the idea of formal equality. That's the concept that the law must treat everyone exactly the same, regardless of where they started in life. The logic here is that in a society fractured by apartheid, treating unequals as equals only freezes inequality right where it is. Instead, the court firmly champions substantive equality. This is a completely different approach. It actively acknowledges past disparities and permits positive measures to actually dismantle systemic underprivilege. Think of it like this. It's about leveling the ground itself, not just treating everyone the same on a field that's totally uneven to begin with.
Writing for the majority, Justice Moseneke delivered this incredibly powerful thought. He wrote, "The Constitution enjoins us to dismantle them and to prevent the creation of new patterns of disadvantage." He argued that substantive equality isn't just some passive, nice-to-have ideal. It is an active constitutional command. It literally requires the state to actively fix the deep scars of the past, even if that means distributing resources differently in the present.
But to make sure these restitutionary measures are used fairly, Justice Moseneke established a very specific three-part internal test. For a measure to be legally valid under Section 9(2), it has to meet three criteria. First, it must target persons or categories of persons who were actually disadvantaged by unfair discrimination. Second, it must be genuinely designed to protect or advance those specific people, so it can't just be arbitrary preference. And third, stepping back and looking at the big picture, it must promote the long-term achievement of equality in society.
Section 5. The final verdict.
So how did the Constitutional Court apply this checklist to Mr. Van Heerden's case? Ultimately, they unanimously overturned the High Court's decision. They ruled that the differentiated pension scheme was absolutely 100% constitutional. It was a perfectly valid restitutionary measure under Section 9(2). The court basically said the government didn't need to prove some absolute mathematical necessity to lower one group's funding to raise another's. It was entirely rational to allocate public funds based on the distinct, historically driven needs of these different groups of parliamentarians.
And the state brought the receipts to back this up with undeniable actuarial data. When you look at the numbers, even with that lower 10% employer contribution to the new fund, Category C members, like Mr. Van Heerden, remained a highly privileged class. Why? Because they were still drawing on that old closed pension fund. Their overall pension payouts were, on average, nearly 3 times larger than the new Category B members. 3 times! So the real crucial takeaway here is that Mr. Van Heerden wasn't actually being economically marginalized or stripped of his dignity at all. He simply wanted to maximize his financial benefit on top of an already massive, pre-existing historical advantage.
Now, in fairness, Van Heerden's legal team did point out a tiny minority of exceptions. They called them the jammer gevalle, which is an Afrikaans term that loosely translates to the unfortunate cases. This was a tiny group of roughly 13 to 15 Category C members who had served less than 7.5 years before 1994. Because of that short tenure, they only got limited lump sums from the old fund, not the massive ongoing pensions. Yet they were still hit with that lower 10% contribution rate in the new fund. But the court held firm here. They said a tiny minority of exceptions, these hard cases, doesn't invalidate a broadly effective, totally rational remedial scheme that was designed to uplift the vast majority.
What's truly fascinating, though, is the rigorous legal debate that happened within the court itself. So all the judges agreed that the pension scheme was legal, but they actually took totally different paths to get there. Justice Moseneke said the scheme perfectly fit Section 9(2) as a protected restitutionary measure. However, Justices Magaro and Gobo wrote concurring judgments saying, actually, scratch that, it doesn't perfectly fit 9(2) because the favored group included some white politicians who weren't victims of apartheid laws. Instead, they argued the scheme was valid under Section 9(3). They basically said, yes, it discriminates between old and new members, but that discrimination is legally fair because it pursues a legitimate societal goal of equity and does absolutely nothing to impair the fundamental human dignity of those old members. And Justice Magaro really grounded all this technical legal theory in the stark human reality of South Africa's history. She wrote, not only did apartheid degrade its victims, it also systematically dehumanized them, striking at the core of their human dignity. Her point was that these restitutionary measures are not just about shifting money around on a spreadsheet. They are fundamental, necessary tools required to actually restore the human dignity that was stripped away by decades of institutionalized oppression. It really is incredible to see how a democracy navigates the ghosts of its past to build a more equitable future.
This case absolutely proves that equality isn't just treating everyone exactly the same today. Sometimes it requires acknowledging the completely unequal starting lines that were drawn yesterday. Which leaves us with a vital, deeply complex question to ponder long after this explainer ends. As we look at institutions worldwide, how can a society successfully balance absolute fairness for the individual with the necessary justice for historically disadvantaged groups? It is a tough question, for sure, but as we've seen today, attempting to answer it is the true work of justice. Thanks so much for learning with us, and we'll catch you next time.